Hi, I'm Christine Sanders, and I will be talking about the Florence County School District 4 versus Shannon Carter. I teach sixth grade science for Basehor Linwood Middle School in the Basehor Linwood School District in Basehor, Kansas. I've been teaching science for 16 years. All right, here we go. Florence County School District number 4 versus Shannon Carter. The background for this case is that the IDEA, or the Individuals with Disabilities Education Act, requires that state-funded educational institutions provide disabled children with FAPE, or a free appropriate public education. The problem here is the appropriate part of that act. Shannon Carter was a ninth grader in a school that was a part of Florence County School District number 4 in Florence County, South Carolina. In 1985, Shannon was classified as learning disabled, and her school created an IEP for her. Once the IEP had been created, they called in Shannon's parents to go over the IEP with them. Her parents felt that the IEP goals, which set her up to make 4 months progress in reading and math throughout the entire school year, were inappropriate because they were not challenging enough, and thus they considered her education to be inadequate. Because of this, they requested a hearing to challenge the IEP. While they challenged the school and were awaiting the decision, they enrolled her in a private school. They chose Trident Academy because it specializes in educating children with disabilities. The challenge was rejected by the public school because both the local education officer as well as the state educational agency hearing officer rejected their claim, upholding that the original IEP was adequate, even though her goals only put her making 4 months progress in an entire year. It was at this point that Shannon's parents filed the suit, claiming that the school district had not followed IDEA guidelines in providing Shannon with a free, appropriate public education, and that because of that, they should be reimbursed for her private school tuition. They filed this in July of 1986, and it was decided November 9, 1993, by then Associate Supreme Court Justice Sandra Day O'Connor. It first went through the district court. The district court stated that they were in favor of reimbursing the family for tuition costs because the Trident Academy had provided her with an appropriate education, which the public school had failed to do. So they ruled in favor of Shannon's family. They next went to the Court of Appeals for the Fourth Circuit. The school district appealed, stating that because they had not chosen to place Shannon in the private school, they were not financially responsible for her tuition. The Court of Appeals ruled in favor of the Carters because there was no particular wording in the act stating that the public school needed to approve of the private school placement, stating that the state approval requirements only fell to the school district if they were the ones placing the child in public school. They also determined that because the public school had failed to provide her with an appropriate education, placement in the private school was appropriate because it allowed her to receive educational benefits. The Court of Appeals Public School District also stated that they should not be held responsible because the private school did not completely comply with IDEA. The private school in this case did not comply totally with IDEA because they did not create their own IEPs and they did not meet all of the standards of the state educational agency because some of their staff at the time were not state certified. The Court of Appeals ruled in favor of the Carter family. The claim by the public school was ironic because the school district that was not following IDEA guidelines by providing an adequately challenging set of goals for the student was trying to state that they shouldn't reimburse the private school tuition because the private school itself didn't meet all of the state guidelines. After the Court of Appeals, there were some further changes. The Supreme Court said that though the private school did not meet all of the qualifications under IDEA, because it did allow her to make educational progress that would not have been provided for her in the public school, the parents were granted reimbursement. The fact that the parents had chosen this school and not the state allowed for them to overlook the fact that the private school did not meet all of their requirements under IDEA. The Supreme Court again ruled in favor of the Carter family. But this led to some further changes. Because the ruling conflicted with a previous ruling, the Supreme Court then became involved. Previously, they had ruled in School Committee of Burlington versus Department of Ed of Massachusetts that if a court rules that placement in a private school is more educationally beneficial than the proposed IEP in a public school, the families would be entitled to reimbursement of the tuition for the private school. The ruling in this case conflicted with a prior ruling. There were two problems that were settled with a writ of certiorari for this case. Problem number one, the problem of not knowing which schools were state approved, while also not having the cooperation of the public school district, made it difficult to determine whether the private school was approved by the state as well. So the court decided that the parents should not be barred from receiving reimbursement simply because they enrolled her in a school that wasn't state approved. Because her parents did not know which schools were approved by the state and unknowingly enrolled her in a school that the district claims was not state approved. The second problem was that the public school claimed that being forced to pay for private school put an unreasonable burden on the public school system, and that it opened the door for any unhappy parents to enroll their children in expensive private schools as long as they provided an appropriate education under IDEA. The court agreed with the public school's complaint. To keep this from happening, the public school can either provide the child a free appropriate education within the public school, or they can place the child into an appropriate private school chosen and approved by the state. As long as the school follows these guidelines, they will not be held responsible for reimbursement of tuition. However, the Supreme Court also upheld that parents that decide to change their child's placement during the pendency of review proceedings without the consent of the state or local school officials are doing so at their own financial risk. The only way to actually receive reimbursement for tuition then would be to prove that the public placement was in violation of IDEA and that the private school placement was appropriate under the Act. If the public school is in violation of IDEA, the court is authorized to grant such relief as the court determines is appropriate. The grant relief means that they will reimburse the families, but total reimbursement will depend on how reasonable the cost of the private school was. So this only applies to reasonable tuition amounts. If it was the most expensive school in the state, they would likely not receive total reimbursement. It would seem that the Supreme Court ruling encouraged the parents and the school district to work harder together as a team to meet the needs of the child within the public school system so that the private school reimbursement would not need to be a consideration.